皆さんこんにちは。NGB 意匠ワールドツアー第8回マレーシア編のナビゲーターを務めます。NGB の永田智博です。さて、各国の意匠プロフェッショナルから意匠の最新情報をヒアリングするこの企画。第8回目の本日はマレーシアのSKRINEよりお話を伺います。それでは、スタート。
Hi, I'm Chia from SKRINE, a law firm based in Kuala Lumpur. I'm a partner in the intellectual property department of SKRINE, and I have been practicing for about 16 years. I manage the industrial designs portfolio. To provide you with some background about our firm, SKRINE was established on May 1st, 1963, and is now one of the oldest and largest legal firms in the country. SKRINE is one of the largest full-service law firms in Malaysia, providing a range of legal services to a broad cross-section of the business community in Malaysia as well as abroad. The firm is currently led by 47 partners with over 100 lawyers across the corporate, dispute resolution, and intellectual property divisions. As for our intellectual property practice group, we have about 17 lawyers and a prosecution team of roughly 50 staff. Our IP team advises clients in protecting, licensing, and enforcing their IP rights, whether in the form of patents, trademarks, designs, copyright, trade secrets, or know-how. We act for clients in trademark infringement and passing of claims, as well as in patent, design, and copyright litigation.
Could you give an overview of the industrial design regime in Malaysia?
Industrial designs in Malaysia are governed by the Industrial Designs Act 1996. An industrial design is defined under our Act as features of shape, configuration, pattern, or ornament applied to an article by any industrial process or means, such features appealing to and being judged by the eye in the finished article. A design can only be registered if it is new and does not merely involve a method of construction or dictated solely by function. Industrial designs in Malaysia are granted 25 years protection from the time of filing of the application or the date of the priority application, if any. Design registrations are renewable in 5-year terms. In order to be eligible for industrial design registration in Malaysia, the design must not have been disclosed anywhere in the world, meaning not shown publicly, such as on your website or in brochures. If you have filed your design in another country, you have a grace period of about 6 months to lodge a filing in Malaysia. The Malaysian IP Office, known as MyIPO, generally does not conduct substantive examination of design registrations. Only formality examinations are conducted, and designs are granted registration as long as the formalities are fulfilled. It roughly takes about 1 year for a design to be registered in Malaysia, provided no serious objections are raised by the MyIPO.
What are common designs filed in Malaysia?
The common items which are registered under our industrial designs regime include designs of vehicles such as cars and motorcycles, appliances such as fans, air conditioners, air purifiers, hair dryers, as well as day-to-day household items such as containers, water bottles, and cookware.
What are the more interesting designs filed in Malaysia?
Interestingly, MyPro has allowed registrations of graphical user interfaces, GUIs, as industrial designs. This is despite the definition of an industrial design under our Act not providing support per se for the registration of GUIs due to the lack of a determinable article or industrial process. We have also seen an increase in filings for surface patterns, meaning patterns or surface designs which are applied to various surfaces or mediums.
In what circumstances can industrial design infringement proceedings be commenced by the owner?
The owner may institute legal proceedings against any person who has infringed or is infringing any of the rights conferred and has performed acts which make it likely that an infringement will occur. It is worth noting that proceedings may not be instituted after 5 years from the act of infringement.
What remedies are available for the owner of an industrial design?
The owner may claim for damages or an account of profits and an injunction to prevent further infringement. In situations where an act of infringement may likely occur, the owner may claim for an interlocutory or interim injunction to prevent future infringement.
Please introduce recent cases in Malaysian industrial design.
In a recent case handled by our firm, CMN International versus Dart Industries, the Court of Appeal had to consider whether a sub-licensee had the right to bring proceedings for an industrial design infringement against another person when he or she was not an exclusive licensee. Just to provide some background, the first plaintiff, being the owner of the registered industrial designs, operates as a subsidiary of Tupperware Brands Corporation, a global multinational direct sales company based in the United States of America. The second plaintiff directs the local manufacture, import, market, and sales of goods that apply the features of the shape and configuration of the first plaintiff's registered industrial design. The second plaintiff was also the sub-licensee of these exclusive rights. In the High Court, the learned judge held that the second plaintiff, by virtue of being the sub-licensee of the first plaintiff, had no right to bring an action against the defendants for design infringement. His lordship held that because the relevant provisions in the Industrial Designs Act were not satisfied, the second plaintiff was stopped by its sub-license from filing the suit. The learned judge made a comparison between the Patents Act and the Industrial Designs Act. On appeal, the Court of Appeal set aside the High Court's decision. It held that the learned judge had erred in law to compare the provisions of the Industrial Designs Act and the Patents Act to impose the applicability of the Patents Act provisions onto the Industrial Designs Act. The Patents Act expressly provides that the beneficiary was required to request the owner of the patent to bring infringement proceedings prior to filing the suit. However, the Industrial Designs Act applied to owners of registered industrial design, and an owner is stated to include a licensee. Thus, the Court of Appeal held that the second plaintiff had the requisite locus to sue under the Industrial Designs Act and to seek remedy against the defendants. As remedies sought by the industrial design owner include an account of loss of profits suffered by the local business, this case would have the effect of encouraging local licensees and even sub-licensees to bring an action for infringement as co-plaintiff with the owner of the industrial design, particularly in cases where the owner is a foreign entity.
Thank you very much, Miss Jillian. インタビューは以上となります。もしマレーシア意匠出願について何かご不明点等ございましたら、私たち NGB へご相談ください。皆さん最後までご視聴いただきましてありがとうございます。この動画が役に立ったと思われた方は、ぜひ高評価、チャンネル登録をお願いいたします。次回第9回は大変です。お楽しみに。